We have a huge decision that came down yesterday where the United States was suing the state of Missouri related to their Second Amendment Preservation Act, and the decision is not good at all. And I have read this judge's decision. I have reached out to the Attorney General's office in Missouri, and I have all the details of everything you need to know here on this episode of Guns and Gadgets. If you like the Second Amendment, love the Second Amendment, if you think it secures all of our other rights, today is tough. Then hit that subscribe button down below, like the video, and share it to get this through the anti-gun algorithm, because this is big information and it absolutely affects everything in this Second Amendment Preservation Act movement, sanctuary type movement. And as of right now, it doesn't look good, but this is not over. So here's the first page of this lawsuit. It's been going on for a little while, and you can see it's the United States of America versus the state of Missouri. It says, before the court is plaintiff's motion for summary judgment, the defendant's motion to dismiss under that, and the defendant's motion to dismiss under that. The court, being duly advised of the premises, denies the defendant's motions to dismiss and grants plaintiff's motion for summary judgment. And that is what we're going to talk about right now, the judge's ruling. The background. On February 16th of 2022, the plaintiff, the United States of America, filed a complaint in this court against the defendants, the state of Missouri, Michael L. Parson in his official capacity as governor of the state of Missouri, and Andrew Bailey in his official capacity as the Attorney General of the state of Missouri. The United States challenges the constitutionality of Missouri General Assembly House Bill 85, which is the Second Amendment Preservation Act, signed into law on June 12th of 2021. The United States seeks a declaratory judgment that SAPA is invalid, null, void, and of no effect, and further seeks a declaration that state and local officials may lawfully participate in joint federal task forces, assist in the investigation and enforcement of federal firearm crimes, and fully share information with the federal government without fear of SAPA's penalties. Further, the United States seeks injunctive relief against SAPA's implementation and enforcement by the defendants, as well as costs in pursuing this action and any other just and proper relief. Here's a quick review of what SAPA is and why they hate it so much. The Second Amendment Preservation Act requires state and local law enforcement officials to cease enforcement of federal firearms regulations deemed infringements under Section 1.420 and imposes a duty on state courts and state law enforcement agencies to protect citizens against the infringements identified. I don't see what the problem with that is. The state law enforcement entities have withdrawn personnel from joint task forces and restricted what information can be shared with federal law enforcement agencies. In addition, any person can file a lawsuit against a law enforcement entity knowingly enforcing Section 1.420's infringements, which includes Missouri's Attorney General on the state's behalf. Missouri law otherwise authorizes the defendant's enforcement of SAPA by other means, and state officials may be removed for knowingly or willful failure to perform any official act or duty. For these reasons, the United States injury, in fact, is fairly traceable to the defendants. The causation requirement for United States standing is satisfied. So what they're saying is that the U.S. has standing and this gets to proceed because of that. And that's why motions to dismiss were denied. This judgment then goes into 1934, passing the NFA, and how the GCA came about, and how it's a taxing and a registration requirement for anything deemed, dangerous and stuff like that. And it's leaning on, well, this stuff is already there, and because it's already law, it is presumed constitutional. And you've heard those words before in several 2A cases. Let's jump to the analysis of the judge. The United States argues it is entitled to summary judgment because SAPA is unconstitutional. First, the United States argues SAPA is unconstitutional because it violates the supremacy clause of the federal Constitution, in that its cornerstone provision, Section 1.420, purports to nullify federal law and or is preempted by federal law. The United States argues because 1.420 is non-severable from SAPA's other provisions, SAPA is invalid and unconstitutional in its entirety. Second, the United States argues that sections 1.430 to 1.470 are each independently unconstitutional as violations of the doctrine of intergovernmental immunity. Section 420 violates the Supremacy Clause. The Supremacy Clause provides that the Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be shall be supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. By this declaration, the states are prohibited from passing any acts which shall be repugnant to a law of the United States. The states have no power by taxation or otherwise to retard, impede, burden, or in any manner control the operations of the constitutional laws enacted by Congress to carry into effect the powers vested in the national government. Further, the law of Congress is paramount. It cannot be nullified by direct act of any state, nor the scope and effect of its provisions set at naught indirectly. As such, a state legislature's attempt to impose itself against federal law is a legal defiance of constitutional authority. Now the judge continues and talks about NFA and GCA again, but here's the meat and potatoes of his decision. SAPA is unconstitutional in its entirety. The unconstitutionality of sections 1460 and 1470 likewise renders SAPA unconstitutional as non-severable. Even assuming SAPA's other provisions are susceptible of constitutional enforcement, which they are not, there is no basis to conclude the Missouri General Assembly would have enacted SAPA without the civil enforcement mechanisms set forth in 1460 and 1470. SAPA's practical effects are counterintuitive to its stated purpose. While purporting to protect citizens, SAPA exposes citizens to greater harm by interfering with the federal government's ability to enforce lawfully enacted firearm regulations designed by Congress for the purpose of protecting citizens within the limits of the Constitution. Accordingly, it is hereby ordered the United States motion for summary judgment is granted. It is further ordered defendants' motion to dismiss are denied. It is further ordered SAPA is invalidated as unconstitutional in its entirety as violative of the Supremacy Clause. HB 85 is invalid, null, void, and of no effect. State and local enforcement officials in Missouri may lawfully participate in joint federal task forces, assist in the investigation and enforcement of federal firearms crimes, and fully share information with the federal government without fear of HB 85's penalties. The states of Missouri and its officers, agents, and employees, and any others in active concert with such individuals are prohibited from any and all implementation and enforcement of HB 85. It is further ordered the United States request for costs is granted. It is so ordered by Judge Brian C. Wims, the United States District Court in the Western District of Missouri. I'll link to this decision down below. It is imperative that if you want to get into the nook and cranny of this, that you read it. It's not a tough read. 26 pages, I think it was. But as of now, the Second Amendment Preservation Act in Missouri is unconstitutional and dead in the water. But that's not the end of this case. The Attorney General of Missouri, Andrew Bailey, said this: "As Attorney General, I will protect the Constitution, which includes defending Missourians' fundamental right to bear arms. We are prepared to defend this statute to the highest court, and we anticipate a better result at the Eighth Circuit. The Second Amendment is what makes the rest of the amendments possible. If the state legislature wants to expand upon foundational rights codified in the Second Amendment, they have the authority to do that. But SAPA is also about the 10th Amendment. It's about federalism and individual liberty. So we will be appealing the court's ruling." And like I said, that's not the end of it, because this is probably going to go to the Supreme Court, although the Eighth Circuit is a very favorable circuit for the Second Amendment. And the Eighth Circuit is the following states: North Dakota, South Dakota, Nebraska, Minnesota, Iowa, Missouri, and Arkansas. And very, very pro-2A area. There's not a stronghold for gun control there. So hopefully just the appeal to the 8th gets it done. But I think the U.S. might push it all the way to the Supreme Court. And if they do, that could be terrible for them if they take an L there. So we'll see what the strategy is behind this. Let me know what you think down below. But the Second Amendment Preservation Act right now is unconstitutional. And if you live in Missouri and you've been living under the SAPA and you have items because of SAPA, I would be cautious. Don't post any pictures or tell people about it, because as of yesterday, they're allowed to come and enforce federal law again. So be safe, stay vigilant, and carry your gun to keep you, yourself, your friends, your family, your community safe. That's what it's all about. You have to ask yourself, guys and gals, why would a government who was created by men with guns and instituted by men with guns, want to take the guns away from men and women so damn bad. Yeah, I'll see y'all in the next one. Take care.